Mr. Langley?
Good morning, Your Honors. May it please the Court, I'm Glenn Langley from Bossier City, Louisiana, and I'm here representing the Bossier Sheriff, Julian Whittington. Today we seek reversal of the trial court's denial of the Sheriff's motion for summary judgment asserting qualified immunity. The question for the Court is whether the Sheriff's actions were objectively unreasonable in light of clearly established law. The District Court did not consider or even address the Sheriff's qualified immunity defense, and the ruling should be reversed for that reason. The claim against the Sheriff is for violation of due process rights for allegedly failing to follow a state statute regarding an appraisal of property prior to a sheriff's sale. And in connection with the summary judgment by another defendant, Mr. Lucky, the District Court found a genuine issue of material fact as to whether the alleged violation actually took place or whether it was a violation at all. But when considering the summary judgment of the Sheriff, the Court held that the federal qualified immunity does not apply to state law claims. The disconnect between those two rulings is that the cause of action is the violation of the plaintiff's due process rights, not the violation of...
I mean, did the District Court say anything about 1983?
Not really, Your Honor. I mean, what it said was that 1983 didn't apply and said that dismissed the summary judgment of the Sheriff in one paragraph. Simply said it didn't apply to state law claims. And I just think that that's fundamentally wrong, because the claim, the due process claim, there were state law claims. There's a 2315 claim, and there's a claim for damages arising out of the alleged failure to follow the appraisal process. But the due process claim is dependent upon the violation of the state statute. And when the district...
But in the original complaint, they clearly delineate a 4365 state law claim. Then the second count is the 1983 claim.
That's correct, Your Honor.
And as to the first, I thought the district judge just said, well, you brought up your request for discretionary immunity too late.
We'll get to I will address it now, Your Honor. The discretionary immunity is not really the issue. The discretionary immunity was brought up as a result of the plaintiff, the plaintiff bringing it up in their reply brief to our motion for summary judgment.
What I'm saying is it's in the complaint, even the First Amendment complaint.
It is.
And you file a 6-page analysis summary judgment opposition where you're asserting qualified immunity, but you only cite federal law.
We only cite federal law, Your Honor, because we're only trying to dismiss the 1983 claims. Once we dismiss the 1983 claims, there's no more jurisdiction. And if the only jurisdiction, the jurisdictional hook that gets this case into federal court is the 1983 claim. And once we dismiss the 1983 claim, then...
We have held in at least one of our cases that under Louisiana law, this discretionary conduct claim that you've made under state law is also appealable just as qualified immunity is in federal cases.
Yeah, that's correct, Your Honor. And I believe...
But here, I mean, as I understood it, you didn't raise the state immunity claim until your reply brief.
That's correct, Your Honor.
And consequently, it would seem that if we followed the usual rule, we would not even consider your state law immunity claim. And the only thing really before us is federal immunity under 1983, qualified immunity, and that's the most that we can do for you. And we would, assuming that you have a substantial claim on qualified immunity under 1983, we could rule for you on that, but then we would affirm the district court with respect to its denial of state law immunity on the grounds that you didn't brief it timely.
Well, Your Honor, I think that it was briefed timely. We didn't raise it initially, but qualified immunity and state immunity was raised as both an allegation, a numbered paragraph in our original answer and as an affirmative defense in our subsequent answer to the third amended complaint. Well, it was not briefed, you're correct, and it was not briefed in our summary judgment motion.
Well, maybe I'm not quite getting this, because the state, the trial judge said that you did not raise it until a reply brief, and now did I hear you say that you did raise it?
I didn't raise it in the motion for summary judgment, Your Honor. It was not raised in the summary judgment motion, but it was raised in the answer.
In the answer?
Yes, Your Honor.
But it was not before the district judge when you asked him to rule.
That is correct, Your Honor.
Okay, well, it seems like you're out of luck on that issue.
Well, we're trying to get the 1983 claim. That's my focus today, Your Honor, is on the 1983 claim. Once the 1983 claim is properly disposed of, I think that the state law claims, because there are some claims that, as to the state law, that which I don't believe we're entitled to immunity, that we can deal with those in the state court, because I think the whole case will have to be remanded after the 1983 claim is dismissed.
So, in other words, what you're aiming for now is for us to dismiss the 1983 claim, and then you want to get it back in the state court? Is that what you're saying?
Well, I think that what will happen, Your Honor, is, first of all, I believe that this court has the authority to address the state law immunity claim, even though it wasn't pled initially pled in the summary judgment motion.
That's permissive. We could.
It
but
could.
We wouldn't reverse the district court for not reaching it.
You could, Your Honor. The court has the authority to do that. Secondly, I think that if the court does not exercise that authority, I think the court should, because the district court did not address the 1983 claim.
Well, I think your argument is it did, but it just wrongly did.
Well, it said qualified immunity doesn't apply to the state law claim.
Well, no, but it also said even as to the federal qualified immunity, it's clearly established. Either it's just obvious, it's obvious to any government official you can't give the result to one of two warring parties, or separately, I thought Judge Hicks cited Louisiana law to say surely a sheriff who's going to pick that third appraiser can't pick one that's unqualified. That's law already. So how could it not be clearly established that they can't pick an appraiser who's the choice of one of the two parties?
I think that the cases that Judge Hicks cited do not stand for the proposition that the court could not, for example, the Ville Platte case, the Ville Platte Bank case, clearly distinguishable. It's a case involving a deficiency judgment, and the deficiency judgment, this is a Third Circuit case decided in the mid-'80s. The deficiency judgment debtor was suing the sheriff's insurer to say that an unqualified appraiser.
But if that's the law, which makes sense to me, sheriff can't pick unqualified appraiser to break the tie, how could it not be also obvious that a sheriff can't pick someone worse than unqualified, someone that the plaintiff or one of the judgment creditor wants?
Certainly, Your Honor, the judgment creditor had input, gave the CV to the sheriff. But in this case, we have to remember that the appraisal was of a promissory note.
Yeah.
And the
The appraisal, I didn't get that. The appraisal of what?
The appraisal, the property to be sold, Your Honor, was a promissory note secured by a mortgage. And how does one appraise a promissory note? Well, this sheriff had never encountered that sort of situation, searched in vain for a qualified appraiser, and then asked the seasoned creditor, something that sheriffs do all over the state.
It seems now that we're getting into the sheriff as the sheriff. I mean, we're not talking about qualified immunity for individual actions anymore. The sheriff, as I understand it, had nothing to do whatsoever with any of the facts that constitute the claim of the plaintiffs here. It was done by deputy sheriffs and other people in the office. The only thing before us is qualified immunity for the sheriff in his individual capacity. That's all that's before us.
That's correct, Your Honor, but the complaint does specifically make allegations against the sheriff in his individual capacity.
But there's no evidence, as I understand it, maybe they'll tell me where I'm wrong, but the sheriff did not do any of this.
The sheriff did not have any direct input, although there's some
So,
indication that he may have had.
Why doesn't that, if that is the case, why doesn't that support qualified immunity of the sheriff? And in this particular appeal, and you kick it back, and he's still got the answer for his role in his official capacity.
I believe that's true, Your Honor. I think that insofar as the sheriff had.
Then he's also got the answer for the claim of under state law for his decision as a matter of policy.
That's correct, Your Honor, although I'm not sure that there was a policy allegation. But there was, Your Honor, consultation with counsel, with the sheriff's in-house lawyer on this particular sale, simply because there was not, this had never happened before. It had never come up before.
When you started to answer, although there were some indicators that.
There were some indicators that the sheriff did participate in at least a consultation.
The sheriff himself personally?
Sheriff himself personally, at least the issue was brought to him. Sheriff, we don't have, this has come up and we've never seen it before.
And what was the sheriff's response?
The sheriff's response was, talk to Mr. Sutherland. He's our in-house lawyer. Let's ask him what he.
That's direct involvement.
That is his direct involvement, Your Honor. And that, of course, was not raised by the plaintiff, but I think that the evidence does show that. So his direct.
Raised by the plaintiff, what do you mean by that?
Well, this came out in discovery, and it wasn't alleged. It was alleged that the sheriff had some personal involvement, but the sheriff's consultation, it came up in some discovery, I think in a deposition of one of the sheriff's employees who actually contacted the appraiser.
When the sheriff moved for qualified immunity, did the plaintiffs point to that evidence of his personal involvement?
No, Your Honor.
Well, that's a little tricky. You're being candid and acknowledging the facts are there to support the allegation.
Absolutely, Your Honor.
But your position is, I think, that there's still no clearly established law, just that because there's nothing telling sheriffs what to do.
The statute is devoid of anything telling the sheriff what to do.
And the district court actually sort of acknowledges that.
That's correct, Your Honor. It doesn't sort of acknowledge it, black letter.
Yeah.
That's what he says. I mean,
Good correction.
Judge Hicks says that. And
So why wouldn't that decide, remind me, how did Judge Hicks say that? I know that in his order, the sheriff is actually almost an afterthought. It's around page 30. So you think that's just what happened?
Your Honor, I think that's what happened. I think the district court recognized that this was a fight between two people who had a scheme going to buy property in somebody else's name and then turn it over to the person who was funding it. And that's what was going on. And when the person decided not to turn it back over to the person who was funding it, that's when all these state court lawsuits.
This is 13 years of litigation.
Yes, Your Honor.
Our record is 11 volumes long.
Yes, Your Honor. And in the sense of getting the sheriff out on qualified immunity before we get involved in extensive litigation, if there ever was extensive litigation, this is it.
Well, where is this matter of curiosity, but where is the property at this point? In whose hands is the property, and is anybody profiting from the property at this moment?
I don't know the answer to the second question, Your Honor, but the property is in the hands of the Lawlers, Magnolia. In the hands of
the Lawlers?
The Lawlers, the person whose counsel you're about to hear from.
So they have authority at this, as far as the record is concerned, they have authority at this point to do with that property whatever they want to, if they can find somebody that would buy it that has this cloud over it.
It's quite a cloud, Your Honor, I believe, but I believe your statement is correct.
And the payments on the note are not suspended?
The payments on the note have been suspended.
Oh, they have been suspended.
That's my understanding. Again, that's not something my client's involved in, but I think they have been suspended. I'm here to ask the court to let my people go.
Right, but there, obviously you look at the Lucky One reversal, there's a stench over this case. It's disconcerting, and the question is, does it extend to the sale and seizure and the appraisal process? And of course your argument is innocent sheriff wasn't involved, just executing a writ.
Right.
But the record is open to a different viewpoint.
I do agree with that, Your Honor, but the record is open, as are the facts, and the law is open too, as to what the sheriff's responsibility was. And when that is the case, then the actions that he took on advice of counsel, I think entitled him to qualified immunity.
Thank you, Counsel. You have rebuttal time.
I'm sorry.
You have rebuttal time. We
Thank you, Your
appreciate the
Honor.
argument.
Thank you.
Mr. Martin?
Good morning. May it please
Who is your client now?
Mrs. Lawler and Magnolia Island Plantation, LLC. I am Andrew Martin. The sheriff handed over the administration of this sale to Mr. Lucky, the seasoned creditor in the action, and Mrs. Lawler's longtime adversary in litigation. He did this, he handed it over to Mr. Lucky without providing any oversight of who Mr. Lucky would select as the definitive appraiser, and no input as to what that appraiser should be appraising or how he should do it.
Counsel, your claim is lack of notice as to the third appraiser, is that correct? The appointment of and the work of the third appraiser, the valuation, is that correct?
Lack of meaningful notice and meaningful lack of opportunity to be heard.
All right. Tell us, let's start, since counsel said this is a 1983 claim that he's after.
Yes, sir.
And seeks relief from, so we're going to focus on that. And since we're suing the sheriff in his individual capacity, maybe you could start by telling us specifically, factually, what did Whittington do to violate a civil right, which I understand is the notice provision, a civil right that was possessed by your client? What did he do factually?
Factually, he did what opposing counsel just conceded up here.
But is that what you argued in the district court? Because I don't recall that being part of the record, that the issue was brought to him, he sent them over to counsel for advice from counsel. So that's the tort that we're talking about, is that correct?
As far as the tort claim,
Well, I'm using the word tort claim within 1983, not
right,
the other.
the wrongdoing by the
We had
sheriff.
a bunch of other tort claims. I'm not speaking of those. I'm talking about 1983.
Right.
The tortious conduct, the civil rights violation, is that he sent his staff members over to talk to the sheriff's counsel.
And as he just said, the sheriff's counsel apparently said, maybe you should reach out to Mr. Shelton.
Okay, but then now that's the sheriff's counsel. Do we
Then-
know that the sheriff himself, Mr. Whittington, the individual, then called Mr. Shelton and said, hey, give me the name of a third appraiser?
It appears
Did he do it?
It appears that he told his subordinates in the office to do it. Call Mr.
Well, it appears. Where is that in the record, the evidence that he instigated the call to Mr. Shelton?
I would have to go back and look at the record as far as where that affirmatively happened, but we do have a concession from counsel right here that that is what happened.
That he sent them to counsel, not that he
I believe he just said that
he called Mr. Shelton.
I believe he just said that the sheriff told his subordinates to call Mr. Shelton. If that's not correct.
Well, that's not how I understood his concession, but he can straighten that out when he comes back up. A record site would be really helpful right now as to what Whittington did, because we're talking about him in his individual capacity. So let's shift gears now. What did you argue that there was some type of established policy or practice in the office that Whittington was responsible for? Was there any argument along those lines?
As far as that would go towards the official capacity claim, Your Honor.
Okay.
I didn't get that. You said,
Well, as far as established policy or practice, I think that would go to the question of whether we've got a claim in the
you did allege that?
that was part of our allegations as far as the official capacity claim.
That's not before us at all now.
I don't believe that is, Your Honor. So we did make some out.
Following up on what Judge Engelhardt was saying, even if the allegations that have been made with respect to the sheriff's involvement here, whenever the motion for qualified immunity was made, did you submit that as part of the evidence that you had against the sheriff for violating your constitutional rights? Was that even mentioned? We're told that was not even part of the record that was brought to the attention of the district court in ruling on qualified immunity.
As far as the sheriff's involvement,
Correct.
we submitted evidence about what the sheriff's subordinates did.
Okay, only as subordinates.
Yes,
So, I mean, as far as the sheriff's individual liability is concerned, you're telling us that there was nothing before the judge at the time that he ruled on qualified immunity that implicated the personal conduct of the sheriff.
I believe we alleged that the sheriff was personally involved in our complaint. And the sheriff, when he submitted his motion for summary judgment, did not argue that point at all, did not deny that point. Appears to, again, have conceded that the sheriff was personally involved in some way, and the only argument the sheriff has presented is that that personal involvement was not contrary to clearly established law. That's my understanding, reading both the briefs at the district court level and the appeal briefs. It does not appear the sheriff has challenged that in any way, and I'm not sure it's before the court as to the question of whether we have brought a 1983 claim, because we have not specifically alleged in sufficient detail that the sheriff was personally involved.
Well, as I understand your response, either you don't know whether it was or it was not brought to the attention of the judge. You cannot tell me that his personal involvement was brought to the attention of the judge when the judge was ruling on qualified immunity.
I cannot tell you from memory if we briefed that specific point.
Well, you should know that, it seems to me.
Yes,
If
Your
you're
Honor.
going to argue a case, I mean, you need to know your case.
Yes, Your Honor. Our focus factually was on what the sheriff's subordinates who had a more active role, and I'm not denying that the sheriff had a role himself, but we focused on what we had the most evidence on, which was the Miss Flournoy.
They're not defendants, though, are they?
They are not, Your Honor. But
It's the sheriff.
that's right, and we believe they were acting according to the sheriff's instructions.
Yeah, okay, but we have 1983 cases here all the time where deputies and patrolmen, police officers are on trial for their individual conduct. And under 1983, the scrutiny is going to be on what they did to violate civil rights. And in this case, the civil right of being provided adequate notice, you're alleging that was violated by somebody in the sheriff's office, but you haven't cited to record evidence what Whittington did.
Yes, Your Honor, and I think we would have submitted more robust evidence on that point. Had the
Would have doesn't address what we have today. We have a record today that the panel is going to go through and scrutinize to verify the arguments that prevail. But we don't have, if you can't tell us in the record, maybe it isn't there, what Sheriff Whittington himself did as part of this violation, then it's not helpful to us just to say, well, we alleged in the complaint that he knew or that counsel just conceded. We need something in the record to support what the district judge did.
Yes, Your Honor, and I understand that. I understand that respondeat superior is not a sufficient basis at this stage. However, that was not invoked in the sheriff's summary judgment to which we were opposed. We did not file our summary judgment on this point. They filed theirs. They did not move to dismiss, for instance, on the basis that we hadn't filed in 1983.
I mean, it seems to me the only thing that we're considering is their motion for qualified immunity. Now, you started mentioning that you filed a motion. It didn't have anything to do with qualified immunity.
No, Your Honor, I was saying that we did not file a motion for summary judgment on this point. That
You're
was,
saying in the 6 pages of analysis on the opposition summary judgment, they never bring up this as a defect.
that's correct.
Chief Judge Hicks didn't see any defect.
Correct.
They're making a concession today. Facts are in there, and you alleged it.
Yes,
That's your argument on this point.
that's my argument.
The sheriff got the call. The allegation is from Lucky. These cops, patrol cops, didn't suddenly decide to call people. But the issue that I thought was briefed, instead of pretending that the sheriff had nothing to do with this, I thought the issue here is that Chief Judge Hicks says, I acknowledge there's no law. And your brief says that's what he did. He never got to the second prong. So you're asking us to find that it's implicit.
I am,
Right? That's a problem because we don't find clearly established law as to constitutional violations lightly.
I understand that, Your Honor. I think implicit in his holding has to be that
That's the case where we say, oh yeah, there's clearly established law finding, second prong finding implicit but never identified. Can you think of one?
I cannot think of one, but I don't think, to the extent that Judge Hicks in this very long ruling on several motions did not address each specific point, if there was some flaw there, I don't think it changes the fact of what he ruled, which was, I am not extending qualified immunity. To the extent that this court does have jurisdiction over the legal question, this court can determine for itself.
We've got to make an eerie guess, and there's almost no law, and Chief Judge Hicks knows Louisiana law, and he says there isn't any law. So how would a sheriff, what law is a sheriff supposed to look at to suddenly realize, oh boy, you know, I need to find a third appraiser, and I don't really know how to do it?
I think that's a really good question, and it does bring out a point that I think my colleague on the other side, they've conflated our 1980.
No, I'm asking you. Don't criticize them. You've got, a sheriff is just thinking, this isn't my normal work. And I've got two people that are far apart. I suppose lawyers are officers of the court. I'll just call one. Maybe I'm going to get to the other. Where does it say that that's a constitutional violation?
We don't think the question for our 1983 claim is whether he followed Louisiana procedure exactly right. It's that he did not provide the minimal baseline of procedural protection demanded by the 14th Amendment. Whether or not he complied with the Louisiana statute to a T is a different question. He did not do anything that would be sufficient under the 14th.
He calls an officer of the court.
And the officer of the court says, call Mr. Shelton. And the sheriff has admitted that.
So what's the federal law? If you don't want to talk about state law, what's the federal law says that a police officer can't do that?
The sheriff has admitted he was aware that Mr. Shelton was Mr. Lucky's attorney. And he only provided notice to Mr. Lucky that he was, and I use quotes here, recommending. He was going to accept a recommendation from Mr. Shelton. Mrs. Lawler was not given notice that the sheriff was going only to Mr. Lucky, asking for a recommendation, and allowing Mr. Lucky to fix the outcome of this proceeding.
Well, that's speculation. All he did procedurally was ask for help. He did speak to one party, but he's not a judge knowing that there's no ex parte contacts. He's a sheriff. Right? Are you saying that when a sheriff picks a third appraiser, they have to give advance notice? Is there any law that says that? Or is it just if they decide to as to one, they ought to as to the other?
I don't think that we had any meaningful notice of the process actually occurring.
So what's your best case that it's clearly established a police officer in the world of legalities can't consult one side and say, who would you think? Who's good up here?
My best case is it arises in a very different procedural context, and I'll acknowledge that, but it's Fuentes v. Chevin. And there the Supreme Court said, fairness can rarely be obtained by secret, one-sided determinations of fact decisive of rights.
It's not that secret if he's talking to counsel.
He's talking to one counsel, and he did not inform us, and we did not even get the Shelton letter until discovery in this case. We weren't aware of any of this as it happened.
But what we're talking about is denial of federal constitutional law. And on the face of it, as Judge Higginson has said, there's no denial of due process to pick up the phone and ask for the recommendation of an appraiser. Now, what I mean, your overall claim is, look, he made contact with the lawyer for the opposite party, and he should have called us for our recommendation, and he acted on the recommendation of one lawyer, and that's not fair. That's what you're saying. And but how does that, what process was he entitled to? Due process, what process was it, what procedural right was he entitled to under the law?
Mrs. Lawler, under the law, was entitled to meaningful notice and meaningful opportunity to be heard about the deprivation of her property right and how it was going to occur. I would certainly dispute the characterization of the sheriff's conduct as accepting a recommendation. If you tell someone you're going to accept a recommendation in this context, you would probably say, okay, you're going to evaluate the credentials of this party that's recommended to you. You're going to make sure he's been given the relevant information. You're going to follow up with him. All of that is lacking here. He asked for a recommendation, but never accepted or rejected that recommendation. He did not speak, the sheriff and nobody in the sheriff's office spoke to Mr. LaCour until the day he turned his appraisal in. I'm sorry, Your Honor.
This is all sort of guesswork on how 4365 operates. And I think sheriffs see it as just ministerial. They get the two appraisers. If they're too far apart, they get a third. That's it. And there's not sheriff noticing, and sheriff's got ex parte restrictions. So what's your best case as to 4365 that sheriffs have to get into the world of notifying? Because ultimately this third appraiser gets identified and the work product's there.
Yes, Your Honor, after the fact. It was a case you referenced, American Bank and Trust Company versus Price, Louisiana Second Circuit case, about having an unqualified appraiser, one with a conflict of interest. And we've got a conflict of interest here, obviously, that the only basis for Mr. LaCour's appraisal, the one that was actually used, and Mr. LaCour has admitted this, the only thing he looked at in appraising the note was the Shelton letter. He did not look at the note himself.
I want to remove to another point that Judge Higginson made, and that is that we decide this on the basis of clearly established. Do you have any basis, any other kind of legal authority that would support that what the sheriff did, assuming that it was a violation of law, was clearly established violation of law?
I think this falls into the category of obvious cases, the sort of cases mentioned.
Okay, you're relying on that.
Hope versus Pelzer.
And so if we don't say this is the kind of conduct that is so obvious you don't need precedent to establish it as law, if we don't hold that, you lose on qualified immunity.
Yes, Your Honor. If there is any possibility that a reasonable official could sit here for a month, because the sheriff reached out to Mr. Shelton more than a month before the sheriff's sale. If any reasonable official could sit there for a month and say, the best idea I can come up with is to reach up over to one party, hand the process over to him, do not check in, provide no oversight, check out of the process entirely, and don't even tell Mrs. Lawler, whose property rights are at stake, that we're doing this. If that's the best idea that he could come up with, I don't think any reasonable official would make that decision.
Do we know how many times, let's just say in the last 10 years, how many times the sheriff of Bossier Parish was called upon to get an appraisal for a promissory note or a piece of commercial paper?
I can't give you statistics, but I can tell you that every single foreclosure in Bossier Parish starts as an action on a promissory note.
No, I understand that, but the appraisal itself is usually 99% of the time involves a piece of real property or a vehicle or something tangible, whereas in this case we're talking about a promissory note in whatever status it's in default or it's current or what have you. How many, do we know that? Was there any argument that, look, this is the procedure the sheriff follows, but in this case, he called Mr. Shelton and he didn't call us? Is there anything to show that he deviated from some type of pre-existing policy?
You just basically, the ordinary man on the street would know he didn't do right. That's basically your...
Anyone familiar with the principles of due process in the property deprivation context, as articulated in Mullane versus Central Hanover, Fuentes versus Chevin, would understand that failing to give Mrs. Lawler notice and opportunity to be heard about the actual process that was going to go into the deprivation of her property would understand that does not comply with the minimal requirements of due process.
Judge Engelhardt's question?
The question as to how often, every time that the sheriff forecloses on property,
I understand that.
we're secured.
The appraisal is not for the promissory note he's foreclosing on, it's for a piece of property, is that correct?
No, let's say he's foreclosing on a mortgage that begins as a promissory note. The default triggers the mortgage. He has to evaluate the value of the note, which is certainly evidenced to some extent by the collateral. What you have in the Shelton letter is a specific instruction to the appraiser: do not consider the collateral property that secures this note. And the reason was that Mr. Shelton had a great incentive to drive down the value of this note. He tells the instructor, the appraiser, intentionally, don't consider the collateral, because that helped his client.
Let me ask one, if I
Yeah, of
may,
course.
one last question. When did your client or her counsel, whether it was you or someone else, when did they find out about the third appraisal? Was it prior to the actual sale of the note, the sheriff actually having the auction?
It was about 2 days beforehand, or 3 days beforehand. My colleague overheard a comment when Mrs. Lawler turned in her appraisal, and he was with her, and he heard something to the effect, and I don't want to speak outside the record, but it's in our amended complaint. He heard something from a sheriff's employee about contacting Mr. Shelton to resolve the discrepancy.
Okay, and was there an objection made at that time?
We
The
filed
appraisal was not valid?
we filed a motion to enjoin the sale in the district court. The district court elected not to hear that prior to the sheriff's sale.
Is that the same district judge that decided Lucky won?
That's right, and waited until the day afterwards and then marked it moot because the property had already been seized. That's all.
Your time's up, but I'm gonna ask one last question. Is there any pending state case left to this? Or is this the tail of the litigation in federal court now? Is there any pending litigation in state courts as to?
No, Your Honor. The state court actions, Lucky 1 has been fully reversed by the Louisiana Supreme Court. Lucky 2 was dismissed by Mr. Lucky himself. There are state law claims.
And the payments on the note have been suspended?
I don't think the payments on the note have been
Because we heard opposing counsel said they have
I
been.
think that's incorrect. We have, just to answer that question, one of the claims by Mr. Lucky in his counterclaim in this suit is that Mrs. Lawler owes him $1.7 million, or his family company $1.7 million, because that's how much the note is worth. This was after. Thank you, Your Honor.
Rebuttal.
Very briefly, Your Honor, I can answer your question. Never. In the last 10 years, I've represented the sheriff for 12 years. We have never been called upon to appraise a promissory note as the item that is to be seized and sold during that period of time. Mr. Sutherland, who was, now passed away last year, but who was the sheriff's in-house counsel, was regularly consulted about civil matters, and it was Mr. Sutherland that the civil department turned to when the issue of the appraisals came up.
Any reason why Shelton would say don't look at the underlying property as collateral?
I'm not sure that he said that, Your Honor. I think that if the proper characterization of Mr. Shelton's letter is, this is what I think you ought to do. These are the factors I think you ought to consider. And
here's one not to consider?
And here's what not to consider. That's right. And my appraiser did this. Their appraiser looked at the value of the collateral. My appraiser looked at some certain discounts because of litigation and the value of the collateral, how to get the collateral out. There are discounts that should be applied, and those are the things that you ought to do.
And just because it is a voluminous record, so I don't pretend to have looked at everything, what did they object or try to object, and the state court said, no, we're going forward with the sale?
They actually filed a lawsuit or a motion to enjoin the
On this
sheriff's
ground, saying this third-party appraiser is a conflict?
That's correct, Your Honor.
So what's the explanation for the state court saying too late?
The hearing did not occur prior to the sheriff's sale. Why it did not occur, I do not know.
But what was the order in
The
response?
order was that the sale had occurred, and therefore the issue was moot, and the motion for the injunction was dismissed. That's my appreciation of the record. I didn't participate, but I think that's what it says. Your Honor, the characterization, and while we're on that subject, Judge Hicks addressed Ms. Lawler's summary judgment. You asked, I believe you asked, whether or not there was a motion filed, and there was a motion filed by Ms. Lawler, a motion for summary judgment on the issue of notice and due process. Denied. Judge Hicks denied it. Said there was a genuine issue of material fact. So it was not clear that she did not get notice. In fact, she had actual notice.
Do you accept their point that it may be that the payments are still owed?
I simply don't know, Your Honor. I simply don't know. We're not involved in that other litigation. And I will say that counsel's characterization that he handed over, that the sheriff handed over the administration of the sale, simply incorrect. The sheriff's department employees, at the direction of the sheriff, talked there, and by the way, there's not a Monell claim, Your Honor. I don't think pled anywhere in the complaint. Directed the sheriff's office employee to contact Mr. LaCour, who was the individual identified by Mr. Shelton, got his curriculum vitae, and then hired. There was a telephone conversation, the record shows, between the clerk in the sheriff's office and Mr. LaCour, hired Mr. LaCour, and
There's no allegation, correct me if I'm wrong, there's no allegation that the appraiser was unqualified as an appraiser. The allegation is that the appraiser gave a favorable result in this particular case. Is that correct?
I believe that's the complaint, Your Honor. Yes. That's
It wasn't somebody just off the street, Mr. Shelton's brother-in-law or somebody like that. It was
Right.
somebody who was an appraiser who had the education and training and so on to actually do an appraisal. Is that right?
To do an appraisal of this piece of property, or this item of property, the promissory note.
You heard our panel pressing opposing counsel as to why your client shouldn't get federal qualified immunity. One would be insufficient pleading. The other, separately, would be legally. There isn't authority that guides the sheriff. Do you have a viewpoint as to which is the stronger way were you to prevail?
I just don't think there's any guidance, Your Honor. It's not clearly established law.
So it's the second.
It's the second.
Not that they didn't plead.
I'm not going to throw out any
No, I
opportunity to
appreciate
win, Your Honor, but the stronger argument is there's just not clearly established law as to what the sheriff should do. In fact, the practice, I dare say, and I hesitate to go outside the record, the practice of every sheriff in this state is that we'll talk to the seasoned creditor if we have a problem with these two appraisers, if they're statutorily.
That is outside the record, and that
It is outside the record, Your Honor.
But both of you argued this very capably. We appreciate it. It's a big record, and it's a difficult area of speech.
Thank you for your patience, Your Honor.
The case is